yes.
Okay, sir. Okay, sir. Resume today, Monday, 28th November 2022, before His Lordship, Honorable Justice S.H. Danjida, suit number NICN/LA/140/2020, between Comrade Bamidele Busari and 1 Comrade Lateef Idowu Oyelekan, 2 Comrade Ahmed Yahya, and 3 National Union of Food, Beverage and Tobacco Employees. Is party present?
But let me ask first whether the lawyers in this case have joined.
Yes, my lord.
Okay.
OE here for claimant.
Okay. OA.
OE.
Okay.
Adi Oshun. For the claimant.
Yes. Yes. Yes, Mr. I think the other time is Mr. Okay, Chuku. So Chuku. IJ Chuku with a lot in years. Yes. Yes.
My lord, this matter is for today is for ruling on the preliminary objection.
Okay, the counsel for the
defendant is appearing with someone.
I'm so sorry, my lord.
Not
Okay.
you.
Okay,
No?
okay.
It's not for you. It's Boluwatifele. This Mr. Ikechukwu is appearing with Boluwatife. Because they are both online.
It's appearing with MC Olatunji, Mrs. and Lay, B.E. Lay.
Yes, B.E. Lay, yes. I know.
Lay or Lee, Raleigh. It's Lee.
Whether Lay or Lee.
It's Lee.
Leigh.
Yes.
Mm.
So they are not in court.
They are in court.
But I've not had any.
So they are yet to talk. It's like they are connecting to their audio or something.
Okay.
I want to mute myself.
Okay.
My lord,
Maybe
you should continue. Once they join, they will let us know.
Okay. So this is my ruling. But by a motion or notice dated and filed on 3rd of November 2021, the defendant applicant prayed to his honorable court for the following orders. Number 1, an order dismissing striking out this suit for lack of jurisdiction. And for such further orders at this honorable court may deem fit to make in the circumstance. The grounds upon which the application is brought are contained on the face of the motion paper. Panel counsel for the applicants file a 5-paragraph affidavit in support of the application and attached 3 exhibits. A written address was also filed to accompany the application. It was the argument of the applicants in their affidavit and the grounds upon which they brought the application that the claimant filed this suit on the 5th of June 2020, and that his case majorly centers on the interpretation of Rule 14, 1CE, and F of the Constitution of the third defendant relating to the duties / powers of the General Secretary of the third defendant applicant. That the claimant was suspended as the General Secretary of the third defendant on the 18th of August 2020 by the National Administrative Committee and was subsequently dismissed as an employee of the Union on the 19th of October 2020 by the National Executive Council. Hence, he is no longer the Secretary of the third defendant effective 19th October 2020. It was also the argument of the applicant that the claimant accepted and fully acknowledged his dismissal as an employee of the third defendant, hence the voluntary withdrawal of his motion and notice dated and filed on 29th of September 2020, seeking to set aside his suspension as the General Secretary of the Union. Applicants further avert that the claimant does not have any suit in any court complaining about his dismissal as an employee of the third defendant since over 1 year ago when his suspension and dismissal were effected. It was also avowed that if the questions submitted to this court are answered in any way, the claimant will not benefit from the outcome of the decision of the court. It was further avowed that the claims of the claimant, which are merely declaratory without force of execution, have become academic, stale, odious, hypothetical, and a waste of precious judicial time unless subsequent suit is filed for mandatory injunctive orders. Applicants stated that there are no surviving live issues present in this suit, and this court has the power to dismiss or strike out this suit for want of jurisdiction. Another counsel for the applicant in his written address raised a lone issue for termination to it, and I quote, whether this suit is presently constituted, has become academic. Unquote. Counsel submitted that this suit resolves around the interpretation of the powers of the General Secretary of the third defendant as enshrined in its registered constitution. The claimant did not seek any executory relief from this court, but what was sought are declarations with regards to the powers of the General Secretary. The submission of counsel that the nature and effect of a declaratory prayer or relief are elementary. The declaratory prayers merely seek the proclamation or declaration of existence of relationship or rights and do not contain any order which may be enforced against a defendant. Where a declaratory prayer is granted, it becomes an order without force of enforcement, citing the case of Ade and Balogun. The council also submitted that an application of a declaratory order is not totally helpless as per its enforcement, that the law requires such applicant to file a subsequent action containing executory prayers on the back of the declaratory orders in order to enforce the orders sought. Council submitted further that the relevance of the above exposition on declaratory prayers or orders becomes clear when viewed from the prism of the claimant's current status as a dismissed staff of the third defendant. It was evidence in Exhibit A and B in the affidavit in support of the claimant, projecting summons, that it was evidence in Exhibit A and B in the affidavit in support that the claimant was suspended as the General Secretary of the third defendant on the 18th of August 2020 and subsequently dismissed from employment on the 19th of October 2021 on extraneous infractions related to the present suit.
Bonds.
The submission of counsel that the claimant has not disputed his suspension or dismissal because he has not challenged his suspension and dismissal in any court of law since August 2020 when the cause of action accrued. Counsel argued that the claimant had earlier filed a motion and notice dated and filed on 29th September 2020 seeking to set aside his suspension, but the said application was voluntarily withdrawn by the claimant and subsequently struck out by the court. Other counsel also argued that having entered a non-contest against himself as an employee of the third defendant, the claimant cannot benefit from any declarations of right to be made in this suit. That is only a substantive General Secretary of the third defendant who can benefit therefrom. Hence, this suit has become academic, hypothetical, odious, spent, stale, speculative, and of no utilitarian value, such in the case of PDP and Ajaripe. Counsel contended that a suit which at its inception may contain live issues, but due to intervening events before or after the hearing has become mute or hypothetical will be held to be academic by the courts. That the attitude of the courts has always been not endorse the suits, but strike it out. Just argue that the court does not make an order in vain. Such in the case of GTS Nigerian and Ministry of Mines and Steel Development, AR Security Solution, and EFCC. It's a submission of counsel that the claimant having ceased to be the general secretary of the third defendant or its employee in any manner, or a member of the union is no longer an interested party in the questions submitted for determination, as a determination of those questions will not confer any benefit on him. Such in the case of Busari and Husseini, where the Court of Appeal held that a declaration can only be made in favor of an interested party. In opposition to the notice of objection, the claimant respondent on the 8th of December 2021 filed a reply on points of law and submitted a sole issue for determination to and I quote, whether by the claimant stroke respondents or noticing summons as presently constituted, this honorable court lacks the jurisdictional power to hear and determine same, unquote. Another counsel for the claimant submitted that in determining the jurisdiction of the court will solely consider the noting processes filed by the claimant, set in the case of Attorney General of Anambra State and Attorney General of the Federation. It is submitted that the claimant respondent has demonstrated by its written processes that this court has jurisdiction to hear and determine the instance case. I've carefully gone through the processes filed by the parties and considered submissions of the respective counsel. Both counsel for the parties in the respective submissions raise one issue each for determination, but I think the simple issue to address is whether there is a living issue in this case upon which this court can make any pronouncement. To the contention of the applicant that this court does not have jurisdiction to entertain and determine this matter because the declaration sought by the claimant relates to the duties or powers of the general secretary of the third defendant. However, the claimant is no longer the general secretary as he was suspended and dismissed. Hence, this suit has become academic, hypothetical, auteur, spent, stale, speculative, and of no utilitarian value. The claimant, on the other hand, has argued that in determining the resolution of the court will solely consider the originating processes filed by the claimant. According to the claimant, he has demonstrated in his original processes that this court has the reason to hear and entertain the instance case. From my look at the originating summons, it was the amendment of the claimant in his affidavit in support of the originating summons that he is the general secretary of the third defendant, and contrary to the provisions of the constitution of the third defendant, the first defendant usurped his constitutional powers and unlawfully took over and continued to perform the functions and duties reserved for his office as general secretary. The first defendant has unlawfully placed himself in charge of the third defendant's secretariat and control the staff and coordinate the activities of the third defendant. The claimant has outlined his rights and responsibilities constitutionally reserved for his office in his affidavit, and also stated that the first defendant does not have the power to direct or compel him to proceed or leave, and unless a pronouncement is made by the court by interpreting the relevant provisions of the constitution of the third defendant, the first defendant would continue to take actions that will adversely affect the true meaning of the third defendant constitution, its members' interests, and the performance of his office as the general secretary. Claimant, based on the fact averred in his affidavit, asked for declarations and raised some questions on interpretation of Rule 14 of the Constitution of the third defendant as it relates to the office of the general secretary of the third defendant. The declarations sought by the claimant are as follows. A declaration that by interpretation of Rule 14C of the Constitution of the National Union of Food, Beverages, and Tobacco employee, the General Secretary, as the Chief Executive Officer of the Union, is in charge of the National Secretariat of the Union and responsible for the general control of all staff of the Union. A declaration that by the interpretation of Rule 14C of the Constitution of the National Union, of the Constitution of National Union of Food, Beverages, and Tobacco employees, General Secretary as the Chief Executive Officer of the Union is the proper officer of the Union, vested with constitutional power to coordinate the activities of all departments of the Union, as well as those of the State Secretariat of the Union. Number 3, a declaration that by interpretation of Rule 14A of the Constitution of the National Union of Food, Beverages, and Tobacco employees, all vouchers raised for payments from funds belonging to the National Union of Food, Beverages, and Tobacco employees must be signed by the National President and the General Secretary of the Union, and any voucher signed by persons not constitutionally authorized to do so is null and void. A declaration that by interpretation of Rule 14F of the Constitution of the National Union of Food, Beverages, and Tobacco employees, the National Treasurer of the Union cannot honor or approve payment of any expenses of the Union contained or receipt of payment vouchers or validly signed by the National President and the General Secretary of the Union. Number 5, a declaration that by the interpretation of Rule 14C of the Constitution of the National Union of Food, Beverages, and Tobacco employees, the power to schedule meetings on behalf of the Union with management of industries under the umbrella of National Union of Food, Beverages, and Tobacco employees on issues relating to workers' welfare, employment, deployment, and other matters related thereto are constitutionally reserved for the office of the General Secretary of the Union. Number 6, a declaration that by the interpretation of Rule 14E of the Constitution of the National Union of Food, Beverages, and Tobacco employees, the National President of the Union has no constitutional power to direct, mandate, or instruct the heads of the department of the Union to report directly to the office of the National President of the Union. Number 7, a declaration that from totality of interpretation of Rules 14A, 14C, and other provisions of the Constitution of the National Union of Food, Beverages, and Tobacco employees, the first defendant as National President of the National Union of Food, Beverage, and Tobacco employees lacks the constitutional capacity and power to direct, compel, and or force the claimant as General Secretary of the Union, Beverages, and Tobacco employees to proceed, force the claimant as General Secretary of the National Union of Food, Beverages, and Tobacco employees to proceed on compulsory leave or any leave whatsoever, and whether any such directive, if issued, is not void and unconstitutional. Number 8, and for such further orders, this honorable court may deem fit to make in the circumstance. It is the law that jurisdiction, of course, is limited to the determination of live issues or questions that are useful, are relevant in the sense that the determination will change circumstances of the parties. In the case of Emegu and Okolocha, the Supreme Court refused the applicant leave to appeal against the decision substituting him as the candidate of the political party for the election for the sole reason that the appeal had become academic, hypothetical, irrelevant, and useless, since the said election had been held and the winner had been sworn in as a member of House of Representatives. That the cause lacks the jurisdiction to entertain academic questions or questions that have no practical value. It was further held that even if a nomination was wrongful, once the election has been held, the wrongful nature of the nomination can no longer affect the nomination and the election. In the case of Obiechina and INEC, it was held that even if the suit of the appellant at the trial court succeeds and the relief claim therein are granted, circumstances of the parties will not change. See the case of INEC and Ilendu. In Abakuba and INEC, the Supreme Court opined that an action becomes hypothetical or raise mere academic point where there's no live matter in it to be adjudicated upon, or when its determination holds no practical or tangible value for making a pronouncement upon it. It is otherwise an exercise in futility. That a suit is academic where it's merely theoretical, makes empty sound, and of no practical utilitarian value to the plaintiff, even if judgment is given in his favor. And a suit is academic if it's not related to practical situations of human nature and humanity. The appellate courts have consistently held in a plethora of authorities regarding circumstances that constitute academic exercise and attitude of the courts thereto. In the case of Obona and FRN, it was held that if no purpose would be served by an action or appeal or any issue raised in it other than its mere academic interest, the court would not entertain it. The law is that it is an essential quality of a suit or an appeal fit to be disposed of by the court that there should exist between the parties a matter in actual controversy which the court undertakes to decide as a living issue. Moreover, a court deals only with the issues and stays clear of those that are academic. See the case of AGF and ANPP, Mamman and Salawuddin, Kwara Investment Property Development Company, and Oluyemi. It is the law that any judgment which does not decide a living issue is academic or hypothetical. It stands in its best quality only as an advisory opinion, and the court will not engage in rendering such judgment. There cannot be said to be a live issue in litigation of what is presented to the court for a decision when decided cannot affect the parties thereto in any way, either because of the fundamental nature of the relief sought or of changed circumstances since after litigation. See the case of Plateau State and AGF. As it has earlier been noted that all the relief sought by the claimants are declaratory ones, and the questions raised are with regards to the interpretation of Section 14 of the Constitution of the third defendant, as it affects the office of the claimant then as the General Secretary of the third defendant. It is clear from the processes filed by the claimant that there does not appear to be any declaratory relief sought by the claimant, and it is the law that where declaratory relief is granted, it becomes an order without force of enforcement. See the case of Ade and Balogun. It was alleged by the applicants that the claimant is no longer the General Secretary of the third defendant, and that appears to be so because the claimant did not counter that assertion in his response to the defendant's application. The claimant did not as well do anything to amend his reliefs in his originating summons to deal with the issue of his suspension and dismissal as the General Secretary of the third defendant. Rather from the above, therefore, I'm afraid that the determination of the claimant's originating summons will end with hollow victory, a victory with no value whatsoever, a victory that cannot be enforced. And that explains why the appellate courts in a plethora of cases have decided that courts should not engage in academic exercise. Rather, the court should restrict judicial time to determine life issues. See the case of Oyenene and Odugbesan. In the light of the foregoing, I hold that the suit having been overtaken by events is academic and hypothetical, and the court lacks the jurisdiction to entertain and determine it. I therefore resolve the issues raised in favor of the defendant applicant, and their objection has merit and is accordingly upheld. Is Mr. Lee? Mr. Lee?
Yes, my lord.
Is B Lee?
B-E, my lord. B-E, Lee.
B.E. Lee.
Yes, my lord.
For the
defendants, my lord. I'm most grateful, my lord.
Thank you.
Thank you, my lord, for the considered ruling, my lord.
Thank you, Mr. Adeosun.
We appreciate, my Lord, for the well-considered ruling. We are most grateful.
Thank you. Thank you.
Thank you.
And now are we to proceed to the next one?
Okay, thank you.
Well, I seek the indulgence of the court to leave the.
Thank you, Mr. Adelson. Thank you. We can leave. Mr. Lee, thank you.
Thank you, my Lord. We are most grateful.
Suit number NICS/329/2021 between one Samuel Nwafo, suing for himself and on behalf of the indigenous and chief of Ofeka village, Umoko village, Umweyi village, Umodokwara village, Umokechi village, Odagwa community, Eche local government area of Rivers State. 2. LR Agro Limited. And 1. Dr. Fred Baribure Wakoy. 2. Daud Kwaso. 3. Joshua Kapo. 4. Prince Pino Nyeche. 5. Kalada Dixon. 6. Lucky Nweke. 7. Alexander Nweke. 8. Alhaji G. Kaiden. 9. Anthony Jogu. 10. Chiwendu Abba. 11. Attorney General of Rivers State. 12. Adama Rivers Limited.
Yes, Apia.
Apia. Queen
Respectfully, my lord.
Yes.
QO Epia. My humble appearance is for the claimants in this suit.
Okay, thank you. Yes, Mr. Patrick. Is Mr. Patrick here?
Yes, my lord, I'm here.
Okay, where are you? I can't see you.
I'm visible, my lord, but I can
Okay.
hear you.
Okay, how are you?
I'm fine, my lord.
Okay, thank you. Patrick
Enebeli, my lord.
Enebeli. CSC.
It's still PSC, my lord.
CPSC.
Yes, my lord.
They have not promoted you.
They've not.
PSC. Rivers State Emoji.
Yes, my lord.
It's I think it's long overdue. Is that not?
It is, but
Yes,
it's a
my
general
lord.
problem, yeah.
Okay. For the first, third,
Yes,
fifth,
yes, my lord.
and 11th defendants.
Defendants, applicants, yes, my lord.
Applicants. Yes, Mr. Karibi.
Yes. M.E. Karibi White, my lord.
M.A.
M.E. Karibi White, my lord. Monima E. Karibi White.
Karibi White.
Yes. Appearing with me, with your leave, my lord,
Okay, yes.
is Ekele Chinda Esquire.
Ekele.
Ekele Chinda Esquire.
Okay, yes.
Our appearance, my lord, will be for the 12th defendant applicant.
Okay.
The 12th defendant applicant, my lord.
Okay, thank you. You are two, you are two applications. The arguments are much. Mr. Patrick and Mr. Karibi White.
Yes,
The
my
arguments
lord.
are much. their mouths. So this is my ruling. This is a ruling in respect of twin notice of preliminary objection filed by the first, third, fifth, 11th, and 12th defendants. The first notice of preliminary objection was filed on the 27th of January 2022 by the first, third, fifth, and 11th defendant, wherein they pray for the following orders. Number one, an order dismissing this suit for want of jurisdiction. Number two, any other order for this may deem fit to make in the circumstance. In notice of preliminary objection is accompanied by a written address wherein counsel for the first, third, fifth, and 11th defendant raised 3 issues for determination, to which: number one, whether this suit discloses any reasonable cause of action against the defendant. Number B, whether the claimant's respondents can maintain this suit against the first, third, and fifth defendants in their personal capacity. Number C, whether the National Industrial Court of Nigeria, Lagos Division, has a territorial jurisdiction to entertain this suit against the respondent. It is a submission of counsel on issue 1 that the statement of fact does not disclose any reasonable cause of action against the first, third, fifth, and 11th defendants, that a cause of action is any series of acts on the part of the defendant which gives the claimant the right to sue. It is the entire set of circumstances or combination of facts which gave rise to an enforceable claim, set in the case of Anabelo and Union Bank. It is also submitted that the court will restrict itself to the facts and the statement of fact to determine whether a suit discloses a reasonable cause of action, citing the case of Rinco Construction Company Limited and VP Industries Limited. Counsel submitted that the claimant's statement of fact do not disclose any wrongful act of the defendants and the consequent damages suffered by the claimant as a result of the actions of the defendant. That the first claimant is not an employee of any of the defendants, and they have nothing to do with the employment of the first claimant and his co-workers. Counsel further submitted that the consequence of failure to disclose a reasonable cause of action is that the court lacks the resolution to entertain the case against the defendant. Counsel submitted on issue 2 that the first, third, and fifth defendant are agents of the Rivers State government and thus cannot maintain the present suit as agent of a disclosed principal, citing the case of EBA PLC and Ogun Dokun. Citation given. It was the submission of counsel on issue 3 that since all the parties in this suit reside and carry on business in Port Harcourt Judicial Division, then the claimant should have instituted this suit in Port Harcourt Judicial Division of the court, and failure to so file the suit in the State Judicial Division deprives this court of the jurisdiction to entertain this case. Counsel cited Order 2, Rule 1 of the rules of this honorable court, and the case of RJ Limited and AMS Limited, James Ibori and FRN, and the case of Fanny Kayode and FRN. Counsel, in conclusion, urged the court to dismiss the case and hold that the claimants cannot maintain this suit in their personal capacity. The statement of fact does not disclose any reasonable cause of action against the defendant, and that the Lagos State Division of the court has no territorial jurisdiction to entertain the action. Claimants, in opposition to the first, third, fifth, and 11th defendants' notice of preliminary objection, filed a written address on the 11th of December 2022, wherein a loan issue was submitted for determination to it. And I quote, whether the honorable court has jurisdiction to hear and entertain the claimant's suit. Counsel submitted that reliefs 1, 3, 5, and 7 of the complaint and statement of fact relate to breach of fundamental right of the claimant, and that the suit has been rightly commenced by way of complaint. It was also submitted that reliefs 2, 4, and 8 of the complaint relate to and arise from the contract of employment between the first claimant and the second claimant, which the defendants have induced the breach. Citing section 254C of the 1999 Constitution and Order 3, Rule 2, Sub-Rule 2 of the rules of this court. Counsel also submitted that a cause of action means a cause of complaint, a civil right or obligation for determination by a court of law, and a dispute respect of which a court by law is entitled to invoke its judicial powers to determine. Citing the case of Chief Afolayan and Oba Ogorinde. Submitted that the complaint and statement of fact have shown that there is a reasonable cause of action against the defendant, that the claimants in paragraphs 5, 6, 8, 9, 10, 11, and 12 of the statement of fact have established that a tripartite agricultural project exists between them and the 11th defendant, for which the 11th defendant incorporated the 12th defendant to undertake the business purpose and activities of the tripartite agreement. That paragraphs 13 and 14 of the statement of fact also show that the employment of the first claimant and other security officers and their accumulated salaries were affected due to non-payment of proceeds from the sale of agricultural produce by the 11th and 12th defendants. So the first submission of counsel that it is the act of the defendant that have frustrated the tripartite agreement between the claimant and the 11th defendant, which led to the termination of the employment of the first claimant and his co-workers. Claimants also argued on defendant's issue 2 that the claimants can maintain this action against the first, third, and fifth defendant in their personal capacity, that where an agent commits a wrongful act in the course of his duty, it can be
I'm no longer here.
and hello, are we back?
Yes, my lord. Okay.
Okay, Mr. Karibi, are you
Yes,
also back?
we're still here. We've been here, my lord.
Okay, we've had this network issue.
Okay.
So on the issue of territorial jurisdiction of the court, which is the contention of the claimant that by order 3 rule 6, the rules of this honorable court, the president of the court has the administrative powers to give direction to the judicial division in which a suit may be had, and the direction of the honorable president is final. It was further argued by the claimant that by order 2 rule 2 of the rules of this court, an originating process may be filed in the court registry in any judicial division other than that closest to the place of residence or business of the defendants. To the argument of the claimant that the necessity of dividing the National Industrial Court of Nigeria into judicial divisions is a matter of administrative convenience, which does not impair or derogate from the decision of the court, citing the case of Echolu and Ogaku. That matters of judicial division, being strictly administrative, do not go to the issue of jurisdiction, citing section 21, sub 1 of the National Industrial Court Act 2006, and the case of Olanian and Oyoli. Council finally urged the court to dismiss the notice of objection. Similarly, the 12th defendant applicant on 29th November 2021 filed its notice of preliminary objection and pressed the honorable court for the following reliefs. Number 1, an order dismissing and order striking out this suit for being incompetent. Number 2, an order striking out the proceedings in this suit taken against the 12th defendant. And for such further order or orders that this honorable court may deem fit to make in the circumstance. The grounds upon which the objection was brought are contained on the face of the notice of preliminary objection. A written address in support of preliminary objection was filed to accompany the objection, wherein counsel submitted the following issues for determination to it. Number 1, whether the claimant has disclosed reasonable course of action. Number 2, whether the second claimant, as its name appears on the suit, is a juristic personality capable of suing and being sued. Number 3, whether this suit is not an abuse of due process of the court. Whether number 4, whether a non-service of the induction process on the 12th defendant does not vitiate the court proceedings. Number 5, whether the non-compliance with order 2, rule 1, sub rule 1 of the National Industrial Court rules as amended does not render the suit incompetent. Number 6, whether the claimants have established any course of action against the 12th defendant. Number 7, whether this honorable court has the resolution to hear and determine this suit on the merits. Counsel to the 12th defendant submitted on issue 1 that the course of action is the entire circumstance giving rise to an enforceable claim, and that a glance at the claimant's complaint and statement of fact shows that the action is bereft of any reasonable course of action. Citing the case of NCC and MTN, Idigbe and Management Consortium Limited. Counsel also submitted that although the claimant in paragraphs 1, 3, 4, and 5 of the particulars of the claim tend to make a claim for breach of the fundamental right and non-payment of salary, but failure on the part of the claimant to forward the very essence of the contract, which allegedly generated the purported debt, render this suit incompetent and liable to be dismissed. The submission of counsel that the first claimant instituted this action in a representative capacity, and it is not so stated in the affidavit of verification of the complaint, nor is it substantiated with proof in the statement of facts. Counsel submitted on issue 2 that it is only juristic persons who have the inherent right and or power to sue and be sued in their names, that non-legal persons or entities may neither sue nor be sued except where such right to sue or be sued is created and or vested by or under a statute. Citing the case of Ike, Med, Mark, and Pfizer, Bank of Baroda, and Yalabani Company Limited. Counsel further submitted that the second claimant is not a company incorporated under the relevant laws of the Federal Republic of Nigeria. The second claimant has not been able to provide any proof of his registration. The courts have held that by virtue of Section 1E, F, and 2C of the Company and Allied Matters Act, now Section 41C of CAMA, certificate of incorporation is prima facie proof of primary evidence that the company is authorized to be registered and is duly registered under the Act. The court has also held in trying to prove that it is registered, a party can only do so by tendering a certified true copy of its certificate of registration as issued by the CAC. Set in the case of Onubre Cherry and Esegini. The council referred to the case of NB Kote and Saraki, Bagudu and FRN, that this suit is an abuse of court process and therefore should be struck out and or dismissed. Council submitted on issue 4 that service of originating process on a party to a suit is fundamental to the jurisdiction of the court to entertain the suit, that in all cases where service of process is to be effected, it shall be by of personal service, which is a condition precedent to exercise resolution by the court, referring to the case of Dixon and Okwe. So also submitted that personal service of resolution process is mandatory unless otherwise ordered by the court of law. Council referred to the provisions of Order 7 Rule 1H, the rest of this honorable court. It is contended that a failure to effect service of the resolution process is fundamental. It's a fundamental defect which goes to the root or life of a suit. That in the instance case, there is no record of the court of the claimant having applied for service of the origination process out of jurisdiction before effecting service of the said process on the 12th defendant applicant. Ghana Council stated on issue 5 that the position of the law is that where a position or method of instituting an action is regulated by statute, it must be adopted and followed by the parties, such in the case of CCB and AG Anambra State. Council contended that the claimants instituted this action in Lagos, which is not in compliance with the provisions of Order 2, Rule 1, Sub-Rule 1, the rules of this honorable court, which is stated that the proper place to institute an action is the division where the defendant resides or carries on business. That in this case, all the defendants and even the claimant reside and carry on business within the boundaries of Rivers State of Nigeria. Thus, the proper forum for the action ought to be the Port Harcourt Judicial Division of the court. To the contention of counsel on issue 6, that the 12th defendant is not a proper, necessary, or desirable party, that before a person is joined as a defendant, the court will take into consideration whether it is possible for the court to adjudicate upon the course of action set up by the claimant prior to joining the person as a defendant, or that the person is someone whose presence before the court as defendant is necessary in order to enable the court to effectively and effectually adjudicate upon and settle all the questions involved. That in the case of Salim and Ifenke, Pinok Investment Limited, and Hotel Presidential Limited. To the further contention of the council that a person may be joined as a party to an action if he be directly, legally, or financially affected by an order made or that is likely to be made by the court in the proceedings. Council argues that from the claimant's claim as contained in the origination processes, there is no claim against the 12 defendants. that for one to be a proper party, he must be bound by the result of the action. And for one to be a desirable party, he should have interest and or may be affected by the result of the action. That a necessary party also is one who is not only interested in the subject matter of the proceedings, but in whose absence the proceedings could not be fairly dealt with. That's in the case of Uku and Okumagba and Green. Another counsel referred to the case of Madukula in Kemdili to submit that the suit is incompetent and the court has no jurisdiction to entertain sent. It was further submitted that based on the incompetence of this suit, the claimant cannot properly invoke the decision of this honorable court, as the issue of jurisdiction is a fundamental prerequisite in the adjudication of any matter. That is, it is the lifeware of all suits, including this one, and why a court does not have jurisdiction to entertain a suit before it, the proceedings, however well conducted, will be a nullity. Such in the case of Adaja and Ajibola National Film Video Censors Board and Okpabio, Anambra State and Niger Care Development Company. In opposition to the 12 defendants' notice of objection, the claimants filed a written address later and filed on the 3rd of February 2022 and raised a sole issue for termination to it, and I quote, whether this honorable court has the jurisdiction to entertain, to hear and determine this case. Counsel for the claimant stated that in order to determine whether this court has the jurisdiction, the court is to look at the course of action and complaint of the respondent, claimant respondent. Set in the case of F. Oil Nigeria Limited and Oyo State Board of Internal Revenue, that in the instance case, the claimant of the noting processes contain declaratory reliefs, consequential reliefs, and injunctive reliefs, and it is certain law that while an action contains different claims, the court has to examine each of the claims for the purpose of determining whether the court has jurisdiction to entertain such different claims. That's in the case of Nwadike, an Administrator General of Anambra State. It was also stated by counsel that reliefs 1, 3, 5, 8, and 9 of the claimant's claims are reliefs relating to, arising from, and connected with the violation of the fundamental right in the course of the contract of employment, referring to section 2541 of the National External Constitution and order 3, rule 2 of the rules of this court. Counsel submitted that reliefs 2, 4, and 8 of the complaint arose from the contract of employment between the first claimant and the second claimant, which the defendant have induced the breach thereof. That this court has the right to hear and determine rights and obligations and claims connected with contract of employment. The submission of counsel in response to issue 1, reasonable course of action. The general rule is that it is the claims of the claimant as endorsed on the complaint and statement of fact that determine the decision of the court to entertain the suit before it. Such in the case of Shell Petroleum Company Limited and XN Federal Limited. It was argued that in the instance case, the claimants have shown in their complaint and paragraphs 5 to 15 of the statement of fact a reasonable course of action against the 12 defendants. On the issue of jurisdictive personality of the second claimant, the other counsel posited that the second claimant is a jurisdictive person capable of suing and being sued, having been duly incorporated in Port Harcourt, Rivers State, Nigeria, as a private company limited by shares on 24th of July 2012 with registration number 1052887 and can carry on business in Nigeria. On the issue of non-compliance with Section 2A of the Public Officers Protection Act, counsel argued that Section 2A does not apply to cases of contract, citing the case of National Revenue Mobilization, Allocation and Fiscal Commission and Ajibola Agency. With regards to the issue of non-compliance with the provisions of Order 2, Rule 1 of the rules of this honorable court, in instituting this action, it is contended that by virtue of Order 3, the National Industrial Court Civil Procedural Rules, this court has the administrative powers to give directions as to the judicial division in which the suit may be had, and the direction of the president of the court is final. That by order 2, rule 2, the rules of this court and originating process may be filed in the court registry in a judicial division other than that closest to the place of residence or business of the defendants. That in the instance case, the claimant filed the complaint during the period of vacation at Lagos Judicial Division, which is the appropriate court for matters arising in the southern region of Nigeria, and was subsequently reassigned to a court in the same judicial division. Council rely on Section 21 of the National Industrial Court Act. Due submission of counsel that this court has the jurisdiction to hear and determine this case, that this suit discloses a reasonable course of action against the defendant, the second claimant, and this is a delusive person capable of suing and being sued, having been incorporated in Nigeria, that Section 2A of the POPA does not apply to cases of contract, and that the administrative powers of the President of the National Industrial Court to give directions as to the judicial division in which a suit may be heard is final. Counsel finally urged the court to dismiss the preliminary objection. So I've carefully gone through the process filed respect to the 2 objections filed by the defendants, having also studied the pleading of the claimant alongside the submission of the respective counsel and the issues raised, which border fundamentally on jurisdiction. I think the simple issue I will address is whether this court has the jurisdiction to hear and determine this case. Reasonable course of action. The defendant in the respective objections contended that there is no reasonable course of action disclosed against them, and thus the case be terminated in limine. It is settled that course of action is constituted by the bundle of aggregate of facts which the law will recognize as giving the claimant or plaintiff a substantive right to make the claim against the relief or remedy being sought. That the factual situation on which the claimant relies to support his claim must be recognized by the law as giving rise to a substantive right capable of being claimed or enforced against the defendant. In other words, the factual situation relied upon must constitute the essential agreement of an enforceable right or claim. See the case of Bello and AG Oyo State. In Akilo and Fayehimi, number 2, it was concisely stated that a course of action is any act on the part of the defendant which gives to the plaintiff his cause of complaint. The 2 crucial factors that must coexist to consider a course of action before the court are the defendant's wrongful act and the consequential damage to the claimant. It does not take account of whether the course of action will succeed or fail. A course of action is valid irrespective of the strength or weakness of the claimant's case. See the case of Idigbe and Agolo. It's also settled that in determining whether the claimant's case has disclosed reasonable course of action against the defendants, the cause shall be heard to the averment made in the claimant's pleadings. It has nothing to do with the nature of the defendant's defense. This cause, as it was submitted by the claimants, will only confine itself to the averment in the pleadings to assess whether there is a reasonable course of action or not. I need to examine here the facts averred by the claimants in the statement of facts. It was averred by the claimant in paragraph 5 of the statement of fact that the 11th defendant agreed with the claimant to cite an agricultural-based joint venture in the first claimant's community, while the first claimant agreed to provide manpower and land for the project, and the second defendant agreed to provide technical expertise and all the required machineries, while the 11th defendant agreed to fund the project. Claimant averred that the second claimant, in compliance with the joint venture agreement, employed members of the first claimant community who worked as security and farmers. See paragraph 10 of the statement of facts. It was also said in paragraph 12 of the statement of fact by the first claimant that the second claimant planted plantain on the land and employ the first claimants community as unskilled and semi-skilled workers. According to the claimant, the second claimant issued letter of employment to the first claimant as community liaison officer, and also issued letters of employment to security officers appointed by the first claimant. See paragraph 13 of the statement of fact. It was further stated by the claimant that the second claimant employed the first claimant as his co-workers and promised to pay them salary immediately they receive funds from the sale of the plantain from the 11th defendant. That the first claimant and his workers have been maintaining the cocoa plantain from January 2017 till date without any payment. See paragraph 15 of the statement of fact. The first claimant in paragraphs 22 and 3 and 24 of the statement of fact stated that his employment as the chief security officer of the second claimant project and the community liaison officer has been determined by the act of the 1st to 5th.
Hello.
Hello, please, a moment, please. It's like my Lord is having network issue. I'm so sorry about
Okay,
that.
thank you.
Let us know.
I think next week.
It's and the government is not a party.
Okay.
We put in a key
like I have problem with the system.
Okay, okay. I'll put it on.
When I'm on it to shut down again.
Oh, yeah. Okay, sir.
Maybe just connection and put your system on.
I have. And I'll put them side by side.
So they be hearing me.
Hello, sir. Can you please hear my Lord? He's going to be talking through my phone. This thing is having problem. Please listen carefully.
Yes, you can hear him.
Okay.
Yes.
Okay.
Okay, madam.
Mr. Patrick, can you hear me?
Yes, you can hear you, sir.
Okay. So,
We can hear you.
I can hear you, sir.
Yes, I've been having problem with my device.
They can hear you, sir.
But the claimant that the second claimant employed the first claimant and his worker promised to pay their salary big funds so that they get from the government sector. And the first claimant and his worker have been maintaining for corporate data. 2017 to zero without any payment. The paragraph 15 for the settlement of facts of the claimant. First claimant in paragraph 22 and 324 the settlement of facts stated that his employment as chief security officer of the second claimant's project and the commercial liaison officer has been determined by the act of the first to fifth defendant, and that fundamental freedom from torture and detention has been violated by the first to fifth defendant, and that they have no such right to so determine its employment. I wish to similarly refer to 1 and 2 containing paragraph 6. Judgment of fact said as follows. A declaration that the arrest, intimidation, torture, and detention of the first claimant was the first to fifth defendant in the course of his employment as community liaison officer and chief security officer of the Benin Venture project is a violation of the first claimant's right to security and personal liberty. The declaration that the forceful dismissal of the first claimant from the employment of the second claimant by the first to fifth defendant, by the first, fifth, 11th to 12th defendant, the violation of the contract of employment between the first claimant and the second claimant. It is my opinion from the above facts and the relief sought by the claimant that the alleged acts on the part of the defendants in the claimant's plea appear to give the claimant a cause of complaint. I need to also state that the allegation about the first claimant that his employment as the chief security officer of the second claimant's project and the community liaison officer has been determined by the acts of the defendant is a fact that will entitle the claimant to hearing on merits of their case. Contrary to contention of the defendant, I do not share the view that there is no reasonable cause of action against the defendant, and satisfied that there is for now a reasonable cause of action against the defendant. The first, third, fifth, and 11th defendants have contended that the claimant cannot maintain the instant action against the first, third, and fifth defendant in their personal capacity. Generally, the law is such that an ordinary agency relationship, the principal is bound by the act of his agent and fall within the scope of his authority. But some agent who exceeds his authority does not bind his principal. However, in tertiary actions, the law of agency appears to be different, in that liability in tort is both joint and several, even for an agent and his principal. An agent, even of a disclosed principal or master who commits a social action, even in the process of employment, is liable personally first and can be sued alone, just as he can also be sued jointly with his principal. See the scene of the Supreme Court in Ifeanyi Chukwu and Sole Bone, Iyeri, and Bendel Feed and Flour Mill. The law is clear that an agent who commits a tort on behalf of his principal are joint tort feeder with his principal and may be sued jointly or severally. See the case of Dume and their limited and obtained. Rather from the above, therefore, the issue raised by the first, third, fifth, and 11th defendants that the first, third, and fifth defendants will be sued in their personal capacity is
resolved against the said defendant. But argued by the defendant in the respective objection that this court lacks territorial jurisdiction to entertain this case because all the parties reside and carry on business within Port Harcourt Judicial Division of the court. I have to refer to Order 2, the rules of this honorable court, which states as follows. Order 2, Rule 1 says, due to the provision of the Act on transfer of suits and administrative process, respect of a matter in which the court has jurisdiction shall be filed in any registry of the court nearest to where the defendant or respondent resides or has presence or in which the defendant or respondent carries on business.
We're not getting the audio.
There is network issues again.
Yes.
There is no audio coming in, and we're not hearing.
It's network issues. Maybe.
Hello, can you hear my Lord now?
No, I can't hear. I can
Yes,
hear
we
you.
can hear you.
I can hear you, but not my Lord.
Hello, my Lord.
Yes.
Maybe your Lordship.
I should go on back?
Yes, is that they can hear you now. Can you hear me?
Okay.
Yes.
Okay.
Yes.
Okay.
I cannot hear you.
In the case of NSP and ACF, one of our ruling a prior objection filed by the appellant held in essence that National Industrial Court has the reason to entertain a criminal matter in Enugu, even though the offense was committed elsewhere. And it observed that the case of RJ and AMS, Supra, Benin Turkey, and Tongo, Ibori, and FRN and Fanikari and FRN submitted by Land Council for the 1st, 4th, 5th, and 11th defendants. The respect of this issue was decided in consideration of Section 21 of the National Industrial Court Act 2006. The cases are irrelevant and inapplicable. Only the issue of territorial jurisdiction raised by the defendants lacks merit and is resolved against them. The third defendant has contended that the second claim is not a legal personality capable of suing and being sued, but the claimants argue otherwise. The law is that for a suit to be competent for adjudication by the court of law, there must be at least a competent claimant and a competent defendant, in the sense that both are the two persons who can sue and be sued. While the claimant or defendant lacks competence to render the action incompetent, thereby robbing the court the required jurisdiction to entertain the case. This is a case of strength from the Benin company and Daniel case, Idigbe local government and Access Bank. I wish to state that the issue of legal personality of the party to a seat is an issue of fact, which has to be proved or disproved by evidence. But the pure defendant in the instance case did not find any affidavit in support of his notice of objection to prove that allegation, nor find any statement of defense to raise the issue of legal personality of the second claimant. Given the circumstance, I think the issue of legal personality of the second defendant is premature for now and is hereby discontinued.
As the court pleases.
Contrary to contention of the second defendant in his notice of criminal objection, does not personally serve with the notion summons. This court on the 3rd of February 2022 letter an order of security service of the notice portion on the second and third defendant, and the objection that it was not personally served is dismissed. Again, the second defendant, the third defendant, has also argued that the reason of Section 2, sub 1, the proper, the case is incompetent. But I wonder whether the third defendant is a public officer who will enjoy the protection of the Act. In any case, I understand that the alleged injury is to be caused to the defendant, to the claimant, is a continuous one, and outside the scope of Section 2A of the Public Officers Protection Act. For all the reasons stated so far, and of the opinion that the chief of objection filed by the 1st, 3rd, 5th, 11th, and the 12th defendant, respectively, lack merit and are accordingly overruled. And all the issues raised by the third defendant are hereby resolved against them.
As the court pleases.
Yes. So, did you hear me?
Yes, my lord. My lord, we're grateful for the well-considered ruling.
Okay, thank you. Mr. Patrick.
Yes, my Lord, I heard you. Well, thank you for that well-considered ruling, my Lord.
Yes.
My Lord, for the 12 defendants, we were not. Yes, my Lord, for the 12 defendants, we didn't really get. I don't know whether we succeeded in any respect.
None.
As the court pleases, we're grateful for my Lord's ruling then.
So you continue coming to Lagos, Mr. Kanyip.
Mr. Patrick, I know you're going to appeal. I'm expecting the notice.
My Lord, is for the Honorable Attorney General to decide.
Okay. So I can give us a date.
What are we adjourning for, my lord?
For hearing now, the objection is overruled, so
yes,
for hearing.
Yeah.
Sometimes it's March. And now?
March or February. I don't like February 21.
No, March.
My load is not too heavy for February 21, my lord. My load is not too heavy for February 21.
I don't know.
21 is not convenient.
FPR, Patrick, and Mr. Karibu White.
My Lord, I'm trying to confirm whether
Okay.
February
is convenient.
21 is not convenient.
If it's
Okay,
not
we go
convenient
for
check for another date.
I just say a clear date.
I want to check the credit for them. 7th March.
10th of March.
It's convenient.
Mr.
Mr.
Kari-
Patrick is okay.
Mr.
It's
Patrick
convenient,
said
man.
It's convenient.
Mr. Karibu White.
It's convenient, my lord.
My
Okay.
Lord, 7th of March is convenient.
Huh?
My Lord,
She
it's
said
convenient.
it's convenient for us.
7th is convenient, my Lord.
Okay, so FPR, Patrick and Karibu, we are going to send the ruling to you via your phone numbers and the various emails.
Okay, thank you, my Lord.
Thank you, my Lord.
Most of that, my lord.
The ruling, in a soft copy of the ruling, the defense via your telephone numbers and email addresses.
Okay, sir.
Most
As
obliged, my
the
Lord.
court pleases.
Most of that, my lord.
So it's 27th of March for hearing.
Yes, my Lord.
Okay.
As the court pleases.
As God pleases.
The other defendant who should issue the hearing notice to be served against another defendant.
Okay.
There are other defendants now.
Yes, my Lord.
So this is the 7th of March 2023 for hearing. That notice to be issued and served another defendant.
As God pleases.
As
As
God
the court
pleases.
pleases.
So Mr. Patrick and Mr. Kanyip and Adrian, I wish you a very good afternoon.
Thank you, my lord.
Thank you, my Lord.
We wish
I
the Lord
wish
the
you a
same.
very good
And
afternoon.
bye for now. I'm not going to say safe journey.
Because they are in their office, my Lord.
Yes.
I'm not going to say to Mr. Patrick and Kanyip. So that will be all for
Thank
today.
you.
I wish you all the best.
Thank you, my Lord.
Thank you, sir.
Thank you, my lord.
Thank you.
My Lord, we apply to exit the Zoom meeting.
Hello. Hello, sir. They are applying to exit the Zoom meeting. You can exit.